of on development proposals. I think there's a law that permits them to not be disclosed until there's a selection made of a particular proposal. But that's something slightly different. More questions? Yes, in back.
To what extent does this apply to Minnesota School Board Association? A list of their members, for example.
The last time I looked, the associations are not subject to the Data Privacy Act. Okay.
It's a nonprofit. MSBA is a nonprofit.
Yeah. Now, I was in a meeting on Friday with a parent who represents a group that's pushing a student privacy law to deal with what's happening, I'm sure, here with computers being given to school districts by vendors and you being handed contracts that are virtually indecipherable, which essentially lets the vendor, like Apple, do pretty much anything with the data your kid puts on the computer. And after we discussed this new student privacy law that this group of parents is pushing, the aide to the legislator said, well, you have to be at your next meeting. And I went out the door and there were all 5 of the lobbyists from the School Boards Association waiting to meet. There's more than 5 of them, by the way. It's just 5 I happen to know. So, I haven't, one of these days when I'm in a kamikaze mood, I'm going to get some legislator who really has to be a kamikaze to introduce a bill that makes all the government associations subject to the Data Privacy Act. So, if you got anybody like that, let me know.
I know there have been attorneys who have posited the theory that if an organization is substantially supported by public tax dollars, such as a school board association or a league of cities, that should make them subject, but I take it you don't feel the law is there yet.
Yeah, the problem is you got to litigate that. It's like too many other things.
Lynell?
Recently, the Strip had an article about how 8% of the police officers live within the city limits. Several years ago, we were trying to get similar data from the school district about what percentage of their teachers live within the district. I don't particularly care to have the individual address of every teacher, but I'm interested in is to slice and dice that data. That data was never responded to. They just don't reply. But so I guess I have 2 questions. One, is that covered under data practices? That's public employees. And then B, what do you do when they just don't respond? You put in another press, they say they're working on it, and they just never finish it.
First thing you do is you go to people like Steve and Pat and tell them the story, because that's just not appropriate, okay? And particularly in a situation when the answer is, we can't give you the address of teachers because they're private data under the Data Privacy Act. That's all they have to say back to you, okay? And if you say, well, cite the statute, it's Minnesota Statute Section 13.43, the personnel data section. So to me, that's, that's just dumb, for lack of a better word.
So they don't have to give us their addresses. They do have to give us what percentage?
No. What they have to give you, if under the Data Privacy Act, is the county in which the employee lives, the city and county in which the employee lives.
The city and county a little bit,
Yeah, no, that's public, okay. And it's explicitly public. It's not so, but what you're raising is the enforcement question, and that's the most difficult question with the Data Privacy Act. Because in the final analysis, you can go get an opinion from the Commissioner of Administration. You can talk to me, and I can tell you you have, John or whatever, we think you have a really good case, but you got to find an attorney who's willing to sue, and you've got to be willing to pay for that.
Right.
Yeah, and that's the problem, and that's part of the reason why you don't get a response, because they know that most people won't do that.
And some of it's different in the attitude of government agencies. I mean, I put in a request about 5 years ago, much like the one that was the basis for Lavor's story, and had no trouble getting both Minneapolis and St. Paul police departments to give me information down to the zip code and city. And I think that the school district is under the same statute.
We got it about 8 years ago, 10 years ago. We just haven't gotten it 4 years ago.
Okay, so let's just say you have a non-responsive agency that you are dealing with, and you have a lawyer who is willing to take this case. Should you simultaneously file with the Minnesota Department of Administration and file your suit?
I request an opinion first, okay?
Okay.
because that gives an opportunity for when you get, if you get a response, which has become a problem with the Department of Administration. If you get a response, then it gives you an opportunity to see what the position of the district is, and we'll pick out districts, and whether or not your attorney thinks that their position is reasonable. Okay. Let's say, for example, in using the example of what she raised, if they came back and said, we can't give you the specific addresses of teachers because they're private under 1343, then don't waste money on an attorney because that's indeed correct.
So you're just requesting some emails between some people, and you're getting non-responsiveness.
Then I talk to an attorney.
I know.
Now, you have. Yeah.
Oh, yeah.
Oddly enough, there's a case in front of the Minnesota Supreme Court now in which somebody has made a very broad request for data in emails and in other electronic files in which certain keywords are used. And the person who's made that request has won at both the district court and an administrative law judge at the Court of Appeals, and is now before the Supreme Court. And as of last week, every government association in this state, the government associations for whom we all pay for, has filed a brief basically saying, don't let this guy win because this is horrible. And it will, I'm going to exaggerate, it will destroy government as we know it, because people are going to come in and they're going to make huge requests for data and we'll just go out of business. Okay. What they miss in that whole discussion, and they've been told this for years, is somebody makes a large request for data, similar to the one in this case. Remember what I told you about time under the Data Practices Act? There's no time imperative for public data. So what we used to advise government agencies when they got big requests, as long as you're making a reasonable response and you say, okay, we'll try and dig this data out for you, but it might take us 2 months. If that's really a reasonable statement of reality, you're not, if you get sued, you're not going to lose. Just not. The government won't, because that's a reasonable response. So.
To go back to her question.
Good job.
I want to point out a couple of other risks and advantages of the Department of Administration opinion. The Data Practices Act says that if you win, you might be awarded attorney's fees. That's all in the discretion of the judge. It also says that if you have asked for an opinion from the Department of Administration and you get a favorable opinion from the department, it's no longer discretionary with the judge to award something. The judge still has the discretion to figure out how much. But if the Department of Administration says you're wrong, you can still sue, and the district court might still go in your favor. But the government entity is shielded from any award of attorney's fees by the Department of Administration opinion.
Would the agency then be compelled to provide the data you've requested?
If the court says yes.
Yeah, actually one of the legal actions under the Data Practices Act is called an action to compel compliance. So.
How do we work to overturn a Department of Administration ruling? How do we as citizens do that?
Call me.
So, following up on her question,
Is there a danger in going to the administration that you get a bad ruling because they've now told the St. Paul School Board that they can meet in secret, which Minneapolis has copied? I mean, it would seem to me that that's essentially a precedent, right? School boards now feel emboldened.
At any given moment, I'm not sure how admin is doing business these days, but at least once upon a time, if you went to them and said, I'm thinking about asking you for an opinion, and here's my issue, subject to qualifiers like lawyers do, they'd say, well, if you ask us that, we'll probably tell you X, Y, Z, okay? And the rationale behind that is we don't want to surprise people, okay? I think they're still doing that, but I'm not sure. So that's part of the way to deal with it.
since so much of this is talking about public data,
that that's what it's about. Can you give a little tighter definition of what falls into public versus private?
I wish I could. This is the Data Practices Act. This much of it, for all intents and purposes, is definitions of various kinds of data and telling you that they're not public. Okay? So it really does depend on what the data is. The way you analyze issues under the Data Practices Act at kind of the macro level, number one, you got to figure out what kind of data you're dealing with. Okay? For example, is it budget data? Okay, that's a fairly clean one. Okay. Once you figure out the kind of data, then you look in the Data Practices Act and see whether or not there's a section that covers budget data. And if there is a section, then how is it classified? So if budget data isn't defined somewhere and classified somewhere else as not public, then the presumption is that it's public. Okay? And that's why it's so important when you ask for data and you get turned down to say, okay, tell me what statute classifies that data as not public. Because then you get a chance to look.
Okay. We just talked generally about the need to craft a request so that it doesn't get you in trouble. For example, that you can ask for summary data.
John mentioned.
You can ask for summary data that is public, but if you're asking about a discipline action against a particular student, that's going to be non-public. And if you ask for it in a particular way that would identify the student, even if you're not giving the student's name, that would still be non-public. And so if you ask for all instances of student discipline involving physical encounters between a student and a teacher from January of X year through May of that year, be able to get some feeling of what has happened, how common it is, maybe even what school it was in. But the more detail you ask for, the more likely you are to not get the information at all. And if the way you ask for it suggests that you already know who the student is, you're not going to get it.
Yeah, John's point is very well taken. A lot of this really has to do with being very careful about how you ask. I can't tell you how many reporters, nobody in this room, would call me up and they'd say, well, you know, I asked the school district for the name of the employee that they put on leave for sexual harassment. Not the way to ask the question. The way to ask for that data is to say, I'd like the names of data, I'd like the names of employees who are currently being investigated, period. Because once you throw in that additional detail pieces John mentions, then for them to say, well, it's John Smith, confirms that they're being investigated for sexual harassment, and until there's a final disposition that's favorable to the government, they can't do that. So thanks for doing that, John. That really helps.
To give you an example of sort of the balancing act here, obviously in Minnesota, the birthplace of charter schools, there's been a lot of debate about the role of charter schools and whether they're better, worse than, and some are and some aren't. And there was one in particular that had a very good reputation, but I'd heard enough things that made me wonder, how do those students do when they leave this elementary level charter school and try and perform in another school system, such as Minneapolis Public Schools? And I explored with a data person there the possibility of tracking on a longitudinal basis the promotion and other test results for these students. And their sense was that that got specific enough that they were pretty nervous and probably wouldn't give me the data that I was looking for. So even though that was not a universe of 1 or 2 students, it was probably at least 20, 30 students a year. So the more specific you are on data on protected classes like students, the more likely you are to run into a defense like that, whereas summary data is at the gross level. For example, I had no trouble getting a district-wide sample of data for various key educational measures that was broken out by large demographic groups, but they were sliced and diced by income and language status. And the groups were broad enough there across a district of 30,000 students that we were able to get some interesting data without disclosing anything about an individual. 35, excuse me. I've been gone for a few years. So, more questions? Yes?
So as far as going in and inspecting it, so there was a situation where they, this entity that we were working with had said that there were hundreds of pages, right? And so the dollar amount was going to be more than what was expected, and so we said, fine, we'll come inspect it. But then like backup was called, so we could have two eyes inspecting, or two sets of eyes inspecting instead of just the one. And then they said, nope, you can't do that. And you weren't specifically the one who asked for it, so we don't have to show you. And tried to cancel the whole viewing. So then I asked for what grounds they have to say that. And they said their grounds were that there were no grounds to say they couldn't. And then they said that they have a policy, but then when I asked to see the policy, that was not available. But let's pretend for a second they did. In my opinion, policy does not trump law. They clearly felt differently about this. But so then when we did inspect it, it was hundreds of pages of like the same 17 emails. And then different, it looked like they had different people with their emails print out their own things. But then this person decided to retract some things where this person did not. This whole area was missing, where in this email it was included. And so, you know, we ended up just getting copies of the things that were relevant. But, I mean, it was just a complete cluster. And, I mean, what do you do with something like that?
I don't know if I can translate that question there.
I got good audio.
Yeah, you got that? Okay.
You were smart to ask them to justify.
Yeah, no.
Right, well, it didn't get me anything because they just sat there like, you know, stone walls, not letting us penetrate the doorway of knowledge.
Part of where, particularly in contentious situations, you should start is, number one, do they really have the policies and procedures they're supposed to have? Okay? And to the extent that they do, well, if they don't, then you could essentially use that against them. Okay? Wait a minute. You're in violation of the statute already, because the statute is clear. They have to have policies and procedures that deal with a number of things. So if the policies and procedures don't deal with what you're talking about, then you say to them, wait a minute, how can you say that? You don't have that in your policy, okay? There's nothing in here, okay? So that's part of the way. And then at some point, you got to kind of shift gears. And you have to, I think, and this is something I'm going to get bigger on, because I think it's, in some ways, it's the ultimate answer. Instead of dealing with the bureaucrats, to the extent you're dealing with an agency with elected officials, like school board members, go to them, and if you pardon the vernacular, raise hell, okay? I went on the Stillwater School's website about an hour and a half ago downstairs in the library. I found their policy on data privacy. I can't find a word about their policy on public access to government information. Now, if there's anybody here from the Stillwater Schools who can tell me where to find it, but that's part of what they're supposed to do, is to have that either posted publicly in the school district offices or somewhere prominently on their website. And God knows in 2017 they ought to have it on their website, and it ought to be easy to find.
But that should be in alignment with the law. I mean, they can't just...
Oh yeah, no, they can't. They can't, for example, say in the Stillwater Schools we charge for inspection. That's just flat out illegal. They can't I don't think they could say because 2 of you showed up to inspect, 1 of you has to leave. But, you know, part of the reality of the people in this room is we've seen really screwy stuff, okay? I talked to a citizen the other day. She was dealing with the attorney for, actually, I think it was, I shouldn't say that. She essentially said, well, you know, I keep trying to go to the responsible authority, which is the technical reality under the Data Practices Act, and I can't find out who the responsible authority is. He said, well, we don't have one at the moment. I'm acting as the responsible authority, and by the way, he's the attorney for that government entity. So right there you have So she says, okay, fine. Here's the things I want to get access to. And he writes them down, writes them down, writes them down. And she then says, can I look at that list because I want to make sure you've got everything down? And he said, and I quote, that's attorney work product and you can't see it. Huh. Isn't that one, John, that just makes you go, my brain's going to explode. What do you mean that's attorney work product? That's what he told her. Now she's feisty, and she fought him, and she got the list. So,
Carla Bates, as a former Minneapolis school board member, do you want to speak up?
No, I just wanted to ask you another question, as in the public's right to know, 'cause I'm now Citizen Bates, but teacher quality. What kind of data can we ask for?
well, your question is what kind of data can you ask for about teacher quality? You can ask for anything you want, but you're not going to get it unless you've got macro stuff that doesn't identify teachers. Okay. The personnel data section of the Data Practices Act was negotiated among the following parties many years ago: the media, the government associations, and surprise, surprise, the public employees unions. Okay. And the way it works essentially is to list specifically to the data element level data about public employees that's public, okay? And a couple of them are trickier than others. John alluded to one. And then other than that, all other data about employees is private. So evaluation data is not on the list of data that are public. So.
But in the aggregate?
In the aggregate, no, yeah, if it doesn't identify, then it's public. But you do run into the problem that John has alluded to. The example I used to use in training about summary data and its creation is if you had a set of data about people on welfare, and one of the subsets was there's a woman in Cochiching County who has a Spanish surname, who's Afro-American and is a paraplegic, that's probably identifies her, okay? And therefore you couldn't release any data about it. So, Cochiching County International Falls.
How are board members of a district classified? We've run into an issue where board members are being classified as volunteers, therefore data about them is not public.
The question is how our data about school board members is classified.
What kind of data? What can just help me wrap my brain? Like,
the fact that one of them is a miserable human being and is obnoxious, and there are emails that say we got to do something about Harry and get rid of him, or make sure somebody runs against him in the next election, that kind of thing. Okay.
No, it's actually settlement data, completed settlement data.
Settlement data?
Mm-hmm. Against board members. That is being deemed private because the board members have been deemed volunteers.
When you say settlement data, do you mean settlement of a lawsuit?
Yes.
There's a specific section of the Data Practices Act that says any data that codifies an agreement between anybody or an employee to settle any dispute arising out of the employment relationship, oh, I know where they're going, is public. Go to your legislator and your legislative body and say we have to fix this, okay? Yeah, because it suddenly hit me what they're doing.
What do you mean by fix it?
Oh, change the statute. Oh, don't you know that this statute gets amended every year, and sometimes in bills that are 40 pages long?
But they have to change a part of the board member classification?
If I understand what they're doing, okay? You'll find Commissioner of Administration opinions about elected officials that basically say it's not real clear to the Commissioner how data on elected officials ought to be handled. And so essentially the Commissioner has deferred to the governing body to decide how it's going to handle that data. They can treat it as employee data or not, okay? If they treat it not as employee data or not as volunteer data, then it's public. Several years ago, I took a bill to a couple of legislators to basically say that data about elected officials is public, period. And I didn't get lynched, but it came close. More importantly, he didn't get lynched. He's a good guy. So.
Question yet? Who would like to?
I'm going to kind of follow up on the school district level here. Is a lot of our school districts use the same consulting firms. Is the information provided by these consulting firms public data that's provided to our superintendents? Okay.
It's subject to the presumption. So for example, if they use she asked about data on consulting firms. If the consulting firm was doing an investigation of an employee, then it's handled under the Data Practices Act, may or may not be public, okay? There's actually I think it's a Court of Appeals case or a Supreme Court case that deals with the question. St. Cloud State University hired a background checking firm to check on people who were applying to be the public safety director at St. Cloud, and a guy who got tens on everything didn't get the job. He happened to be Asian, and he thought maybe that had something to do with it. So he went to St. Cloud University and he asked for the data about him, and they said to him basically, well, we've got this little bit of stuff, but the background checking firm has most of it, and you have to get it from them. And he sued St. Cloud State, and the court said, no. Those data are subject to the Data Practices Act no matter who the outside company is.
And who would you recommend getting that data from, the superintendent or the consulting firm that's providing that information?
In the Data Practices Act, all requests, unless they tell you otherwise, go to what's called the responsible authority. And in a school district, the responsible authority is the person appointed by the board to be the responsible authority. Now, the reason you want to make sure that you either go to who they tell you to go in their policies and procedures, or to the person who's identified in the school board resolution or whatever. The reason for that is one of the things that they'll do to you is, well, you ask the director of personnel for that data. They're not the responsible authority, therefore we didn't receive a legitimate request, therefore you can't do anything about it. So learning, assuming that they have policies and procedures, learning what they say is really important, okay? Which is part of the reason why they're there.
So back to the other thing I was talking about. The group that we were working with is kind of like they don't really have a lot of policies on themselves, and then therefore they're never really in violation. So A, what do you do about that? B, they tried to make things difficult by saying your viewing had to be supervised, and we don't have anyone to supervise you. And then when they did get someone to supervise, it was only for like 45 minutes. And so, is that a thing?
You really are engaged in serious game playing.
Yeah.
I mean, so far I've heard at least 12, 14 of the games most people don't use, okay? You really at that point I think have a political problem that isn't going to be helped no matter what, what I can tell you about the legal stuff. You really have a political problem. And, I really encourage you to the extent that you have an interested media to go to them, okay? And tell them these kinds of stories. I mean, Steve and Gary and Pat can speak for themselves, and Sharon, usually the media is interested in telling the public that this kind of stuff is going on, okay? So. Yes.
My question's on the other side of things. So rather than trying to get information, my children's information was leaked in part of the South Washington County data breach situation that came up. Is there anything under the statute that I can leverage to make some, to stir the pot a little bit with our school board so that they can take some actions to take some protective measures then? You know what I'm saying?
Yeah, her question goes to what leverage do you have in a situation where student data is improperly released, in this case, in a leak? The Data Practices Act has language that says it's an obligation of government entities to provide security for data that's not public, okay? So your leverage really is to say, you didn't live up to your statutory obligation. Now, how do you know they did or they didn't? Well, you ask to see, to the extent that you can get it, what they've done to guarantee, what training they've given to their employees. What are their policies and procedures? Do the policies and procedures include sanctions for what I think is really negligent kind of behavior? And that becomes your leverage, okay? But, within the Data Practices Act, a lot of this stuff is kind of obscure and you have to kind of dig for it. And so here's the advertisement, okay? We answer people's questions on an ongoing basis. And the magic number is 651-699-6553. That's my phone number, okay? And you can call. Now, I'm a volunteer. Everybody on the board is a volunteer. Sometimes I disappear, especially after legislative sessions, because they make my brain explode. But feel free to call. And if you hire an attorney, I encourage them. I encourage you to have them call. I'll talk to them, okay? Because there is leverage. Yeah, and I thought about that with the Washington County thing, because there was a period in which when I was still working, I trained in Washington County. Now this is 20 years ago. I trained in Washington County like 4 times in 2 years. In those 2 years, I got sued 3 times and lost every one of them. And it's like, am I a bad trainer? And I know I'm not a bad trainer. And it's like, you got to do stuff. And this is an example. There has been in the Data Practices Act almost since day one an obligation to secure private data.
Well, and it's FERPA too. I mean, that would be FERPA.
Yep.
Does it make a difference that it's minors that was really, it's that they were minors?
Oh God, no. It's,
Oh, okay.
no,
I didn't know if
from a
there was
damages standpoint, it's worse.
Yeah.
Well,
Yeah.
yeah.
No, so.
So you gave an example back here where where somebody was requesting data and the lawyer was the responsible party, or it was going through the lawyer. So what if it's not the responsible party, but they're still filtering it through a lawyer? Is that standard practice? Is that not standard practice?
Is it standard practice for schools?
Yeah.
It is
Yes.
standard from a school board. It is no question.
All right.
Okay, what time? Can I be nasty?
Yeah.
I can be
Let's
nasty.
go.
For reasons, unfortunately, that I understand too well, is if you say all data requests have to be reviewed by an attorney, what is the practical economic result of that position? Exactly. Okay? And I kept running into that, and I kept running into it. And the bottom line is, if you have well-developed policies and procedures for many of the things we've talked about, you don't have to consult your attorney every time somebody makes a request for the superintendent's salary, okay? Or similar kinds of data. But it's, oddly enough, and some of this stuff is really kind of up here in the universe. I used to belong to a small organization of government types who did this kind of work. And I mean like representatives from like 8 states. And we get together every year and actually we get together and commiserate. And at some point we always had the following discussion. Which attorneys in government are the worst attorneys to deal with? And it was always school board attorneys, okay? And it's like it's become part of their institutionalization, so.
We have a new question here, right?
I just wanted to follow up and say that might be standard practice in Minneapolis. It's not standard practice in every district.
Okay.
So I just didn't want that to be the assumption.
Nope. And good for you, okay? So I said that based on my
In
experience.
this
So,
district, you said?
I said it's not in every district.
Oh.
not in every district.
Are public employee salaries public information, individual?
Okay.
So I don't have to even ask for aggregate, I can say this is, I need the 10, I need the salaries of these 10 people in this school or district office or.
Just don't ask them to make you a list.
Just don't ask what?
To make you a list of those salaries.
Tell me
Ask
the
to see,
difference.
ask to see the data. If they make you a list, they're creating data and they can charge you for it.
Although I will say that when I was at the Star Tribune, we had salary data for every employee in all the major government entities, from the Met Council to the city, the school district. We didn't obviously print it unless we had a reason to, but
You had it.
we had it.
Yeah.
If XYZ person was under investigation, we could dip into that database.
So the difference is you ask for the data, you don't ask for a list.
If they're willing, if they're
What's the difference? Like, I want these 10 salaries. So how do I ask for those 10? I don't ask for the list of 10?
you ask for access to the data that documents the 10 salaries
Well, you
of the
could,
following named people.
you could also just ask for all the employees in whatever universe you're looking at.
Yeah, that's what often we were
And
trying.
then get a spreadsheet on it, just sort it.
Yeah.
And then you, so you're creating your own kind of summary.
No, that,
without-
we often, that, we were asking for exactly that, just so we could slice it and dice it. And again, we were more looking for patterns as opposed to individual stuff, but they just would say no.
What helps is if you can get a sense of how they do business, okay? As in, part of what they have as part of their normal way of doing business
Right.
is a spreadsheet listing all salaries. Then you ask to see that spreadsheet and look at it and pull out the
Exactly,
names.
yeah.
Yeah, so.
One of the most helpful things you can do is just, as Don said, and this is done by federal agency at the federal level. State used to have a forms manual. I don't know if they still do. Just get familiar with the forms that are kept by the government entity that you're dealing with, because those will often be a key to what's available. John?
Just another practical pointer. You may think that having an attorney contact the government agency on your behalf is a sign of strength and is more likely to get you the information you want. Don't, at least in the first instance. Because even though some agencies, like different school boards, will automatically have an attorney respond, once you have an attorney involved in asking for it, it's more likely to get an attorney from the agency involved in responding, which will slow things down and be more likely in many instances to have the attorney be very cautious about what information gets released. It's fine to talk with an attorney in terms of crafting your request, but you probably don't want to have the attorney's name on your request, at least in the first instance. Then if they turn you down, then you can start ratcheting pressure up. But
Gary, you want to add something?
I had an attorney recommend threatening to use an attorney was a good technique.
The potential problem is in using an attorney at the get-go is, particularly the threatening part, is there's all kinds of stuff in here, okay? A friend of mine who used to do data praxis stuff once made a request on the on behalf of a client. He was getting data about her, not about things in general. The response from the government entity was he couldn't have that data because it was confidential. This is welfare data, which is private under the statute. And so when he locked horns, the response was, well, because she's using you, you must be going to sue us. And under the Civil Investigative Data provision of the Data Praxis Act, that's confidential data, and that's the position. And they held to that through 2 or 3 different motions, which cost both sides too much money, and eventually they gave him the data. So,
Gary, you want to add?
I was just going to say, I learned through bitter experience in terms of when you're making these requests, even when you have like a friendly encounter on the front end and you're just trying to find the lay of the land from the individuals, put it in writing and start building a paper trail from day one, because otherwise you'll make this request, 2 weeks go by, nothing happens, You follow up with another call. They say, well, can you write us? So now they've bought themselves 2 weeks' time. So you always want to, even if you have the conversation, follow up with a letter. And email sometimes works, but you want to build a trail, because if you eventually do resort to going to the administrative, getting an opinion, an advisory opinion, you're going to need that paper trail to show what you did and how they responded in order to get that opinion. Which then, if you get a favorable opinion, you can go to them and say, give me the data. Now, you are now insulated from litigation. What's the problem? Give me the data. So you want to build a paper trail, you want to be very methodical, and you don't want to just trust people because they're nice to you on the phone. Because if they decide you're not going to get it, they're going to drag this out forever. It's one, I'm sure every reporter here has seen the tactic is, well, by tomorrow he'll be on a different story. So we're, or certainly by next week or next month, and just delay. So, so build your paper trail.
Good advice. And another issue you'll run into is just turnover in the responsible authority at the district. So it's good to have that paper trail for that reason. It's 7:45. We need to wind up because the building shuts down at 8. There will be board members here if you want to carry on some sort of conversations or get contact information. As I was coming out of the parking ramp, I noticed the sign said it closes at 8 o'clock. So if you're parking there, you might want to pay attention to that. I don't know how strongly they hold to it, but maybe we can write a request and see what the policy is.
Before we stop, was this helpful?
Yeah.